Hello, and welcome to Arbitral Insights, a podcast series brought to you by our international arbitration practice lawyers here at Reed Smith. I'm Jose Estegaraga, Global Head of Reed Smith's International Arbitration Practice. I hope you enjoy the industry commentary, insights, and anecdotes we share with you in the course of this series, wherever in the world you are. If you have any questions about any of the topics discussed, please do contact our speakers. And with that, let's get started.
Hello and welcome back to Arbitral Insights, our series of podcasts here at Reed Smith. Today we've got a fabulous speaker to join me on this podcast, Shreyas Jayarasimha, and I'm very honored to have him with us. He is a distinguished Indian lawyer based in the city of Bangalore. His firm has offices in Mumbai and Delhi as well. And Shreyas, apart from being a very fine counsel, experienced in international arbitration, is also an active arbitrator and mediator. So welcome, Shreyas.
Thank you, Gautam. Privileged to be part of this exercise.
Wonderful. Well, Shreyas, since we are in the new different of COVID-19 and since you are based in India, the first question I'd like to ask you is, how has COVID impacted arbitration in India? If you could give us your thoughts on that, please, Shreyas.
COVID has obviously impacted absolutely everything, and totally unsurprising to note that it has indeed impacted arbitration in India. In the initial days in March, there was severe disruption to hearing schedules. Very quickly, there were technological tools, both older ones as well as new ones, being adopted, and several significant arbitrations have in fact proceeded after a mild disruption. But in the main, the age of arbitrators in India as average is within the risk category of COVID. And so there is a particular impact on physical hearings. There are also severe travel restrictions in place. My own city of Bangalore is in one of the highest spurts of COVID right now in August. And as other cities have gone in and out of strict lockdown, physical hearings have been impacted. However, the silver lining is that arbitrators, young and old, are being compelled to adapt to newer technologies and to press on with matters. So, as you put it, we are getting used to this as not a new state, but as a somewhat normal state. Matters are beginning to proceed once more, at least in arbitration.
Thank you, Shreyas. And that's very helpful. And I'm going to return to some of those themes in some of the further questions I'm going to ask you, because as you will know from your practice as counsel and as an arbitrator, and as you've mentioned just now, arbitration hearings have gone on remotely. Perhaps you could share with us your thoughts as to some of the best practices that you feel there have been in the holding of remote arbitration hearings.
Firstly, it's definitely have a trial. We cannot underestimate the 21st century equivalent of the printer's devil. So there is something of a tech glitch that can almost be promised, especially if there are multiple people dialing in to hearings. So budgeting a time for tech trials has become an absolute essential part of preparation. Second, earlier, counsel especially might have delayed certain parts of preparation of, for example, hearing bundles for last-minute print jobs in circulation at the hearing. That is becoming much more of a challenge. And so all parties have to be far better prepared and rely on comprehensive hearing bundles so that discharge our duty towards ensuring a smooth arbitral process, irrespective of the outcome. There are also other aspects to be looked at, for example, digital hit. We've all seen the reports of appearances, of sounds, and other aspects of hearings which are entirely avoidable. And although there is no printed protocol, there will be soon, there is a reliance on conservative conduct in hearings being the preferred norm. On a lighter note, Indian courts have witnessed situations where counsel have been filmed smoking while arguing before courts and putting up a smoke screen, as it were, of a pleading or a piece of paper between their cigarette and the screen, but not being able to mask the smoke. And there have been others caught in attire which is totally inappropriate. Thankfully, arbitration is not yet plagued by such instances.
Well, thank goodness for that. I mean, well, Shreyas, one of the things that our listeners, well, many of our listeners will not know is that you are a very smart and very handsomely dressed lawyer. So I'm sure that you would always be very well turned out when it comes to hearings. But I was very amused by your story there about lawyers smoking on camera. But I mean, just on a more serious footing, Shreyas, I mean, one of the things that you picked up on in your comments was how the COVID crisis has meant that arbitrators have had to be better prepared, as indeed have counsel. So tell us a little bit more, just perspective, how you think the COVID crisis has forced arbitrators to raise their own game.
At the first instance, I think there have been, in the cases where arbitrations are interrupted, having commenced earlier, people are revisiting, arbitrators are being compelled to revisit their procedural timetables, and having made accommodation for the initial disruption of COVID, having to redraw them and to demonstrate active progress. There are, of course, time limits under the Indian Arbitration Act, and there are decisions of the courts which have said that periods of limitation stand extended where they expire. And also there are decisions that deal with interim orders of courts being extended. And on the question of court assistance in arbitration, I think that's really the aspect that has seen the most massive disruption in India. In cases where there is either enforcement or interim relief, or arbitrators are waiting on some aspect of guidance, that sort of a procedure is most delayed. But from an arbitrator's perspective, I think there are many more new tools available. It's also welcome to see the level of coordination amongst arbitral institutions. And there are hearing centers who are offering not only virtual hearings, but hybrid hearings, partly in person and partly digital. And I think arbitrators are attuning themselves to this way of proceeding. A quick word about how difficult it is for the new arbitrator or an arbitrator in a new proceeding. I think convening the first session and getting over the initial inertia that accompanies many matters will be a little more of a challenge. And in terms of qualifications of arbitrators, technological ability may soon, or basic competence might soon be in the front list of items to look for while appointing new arbitrators.
Yeah, I think that's a very important point you make there, Shreyas. Technology is now here to stay, and there's no doubt that the COVID situation will continue for a while. Hearings will not return to normal for quite some time, and remote hearings are here to stay, and so technology is here to stay. I mean, if you were to give us your thoughts, Shreyas, about some of the technological innovations that you'd like to see more in arbitration, that would be very helpful. And I ask that from the perspective of knowing that you're a very big fan of technology in arbitration. So I wonder if you could give us your thoughts on that, Shreyas.
Thanks, Gautam. I was part of the IBA ARB40 group that put together a list of technology resources that are underutilized by the arbitration community. And that was pre-COVID. Many of those tech tools are very relevant and much more relevant today. But I think, it is often said that a downturn or a crisis is an opportunity to fast forward change. And COVID is certainly proving to be that as regards the impact on technology and its adoption. One immediate and necessary part of technology has been hearing facilities online. There have been varying platforms that have been experimented with by courts in India, and some initial hesitation around certain platforms being avoided by the government. But there have been some lawyers turned entrepreneurs who have created platforms for secure virtual hearings. They developed these technologies even from India. They can be applied anywhere in the world, but they happen to have been developed from India. There have been also attempts to look more closely at transcription services, especially when accents play such a large role in the way the language called English is spoken in different parts of the world. And transcription can, with accented, and India itself has so many languages and a myriad set of accents that one cannot take for granted the accurate transcription of what is said at a hearing. And so I think we are seeing much more close attention to live transcription, especially in accents, more regional. There is also technology being deployed at a little more sophisticated level, where AI and machine language driven algorithms are at work to guide parties to negotiate better, or to identify scenarios that could play out in a given set of situations. So while we're still far away from the day in which we talk about AI as the neutral arbiter or even as counsel per se, but I think the role of assisted tools available to counsel and arbitrators is only growing, and it will likely grow even more. A quick comment on Singapore. I was privileged to set up a chamber in Singapore called ADR last year, and the Singapore government has an initiative called FLIC that looks at adoption of technology in law. And in India, we have had several hackathons where technologists, lawyers, venture capitalists are collaborating to try to foresee the workable technologies for the future. I think, in short, geography remains history and is likely to remain so for some time, which means it is up to technology to give us a feeling of presence digitally. And that is not an easy situation to arrive at, but we're getting there swiftly.
Thank you, Shreyas. I just want to end the podcast with three sort of quick fire questions, if I may, and I'll invite you to answer yes or no to the extent you can. So, just something different for this podcast. And knowing you so well, if I could ask you these three things. First of all, do you think that the COVID crisis has improved or not improved the quality of cross-examination by counsel?
It has improved the quality of cross-examination.
Thank you. And the second one, do you think that arbitration will improve in terms of speed of awards given the COVID crisis?
Ultimately, yes. I think this is keeping everybody more on the toes.
Thank you. And the last one is, do you think we'll ever see a return to old-fashioned in-person hearings again?
No. If at all, it will be with a hybrid element thrown in.
Thank you very much. Well, Shreyas, you've been a wonderful guest on this podcast. I know our listeners will be much enriched by the answers you've given, your thoughts you've shared from your perspectives as a counsel and as an arbitrator. And I hope in a future podcast with you, we can touch on some other issues in arbitration and mediation. So that's for our next installment. But for now, Shreyas, thank you very, very much for being part of this podcast.
Thank you, Gautam. Stay safe and well.
Arbitral Insights is a Reed Smith production. Our producer is Ali McCardle. For more information about Reed Smith's global international arbitration practice, email Jose Estigaraga at jia@reedsmith.com. You can find our podcast on Spotify, Apple, Google Play, Stitcher, reedsmith.com, and our social media accounts at Reed Smith LLP on LinkedIn, Facebook, and Twitter. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. All rights reserved.